Hello friends, welcome back to the series of lecture. This is the 41st lecture of this series of Indian Evidence Act. In this lecture we would start with section 15. Let's see. When there is a question whether an act was accidental or intentional. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention. The fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. अब मान लो आप कहते हो कि मुझसे एक्सीडेंटली ऐसा हो गया, मेरा ऐसा पर्टिकुलर इंटेंशन नहीं था. Suppose that section requires a particular intention and you are the accused and you are claiming that no, it was accidentally happened. I do not deliberately do it. I do not have the intention. अब suppose if it is found, अब same fact may be relevant under section 14 also, क्योंकि सेक्शन 14 भी तो स्टेट ऑफ माइंड की बात कर रहा है, इंटेंशन की तो बात कर रहा है. वैसे 14 इज ब्रॉड, 14 में इंटेंशन, नॉलेज, गुड फेथ, एवरीथिंग इज फॉल, बट दिस सेक्शन इज लिमिटेड टू ओनली टू इंटेंशन और नॉलेज. लेकिन अगर ये सेक्शन 15 नहीं होता, देन ऑब्वियसली यू विल फाउंड इट इन 14. If 15 was not there, then suppose if a question arises whether an act was accidental or intentional, so any fact which go on to prove the intention could have been relevant under section 14 and similar occurrences in the past obviously is relevant under section 14. Here what they are saying is, if act was committed and the accused is claiming that it was accidental, it was accidentally done, I do not have the intention, I do not have the particular intention or knowledge, it was accidentally that happened. Then in that case they are saying that if there are series of that occurrences, series of similar occurrences, if there was series of transactions, similar incidents, and the accused was the part of the transaction, then it is relevant to prove that he had the intention. It is relevant to prove that he had the intention. अब मान लो पिछले कई महीनों से किसी एक प्लेस पे, मान लो दिल्ली में पिछले कई महीनों से मर्डर हो रहे हैं और एक पर्टिकुलर स्टाइल में मर्डर हो रहे हैं. सपोज द डेड बॉडी वाज फाउंड एंड इन द सिमिलर मैनर एवरी डेड बॉडी द थ्रोट इज स्लिट. हर डेड बॉडी का थ्रोट स्लिट हुआ है इन अ सिमिलर मैनर. अब कई इंसिडेंट हुए भी थे, जैसे बॉडी मिल जाता था, नेक नहीं मिलता था, गला काट कर ले जाता था उसको कहीं और डंप करना. अब उस तरीके का इंसिडेंट हो रहा है, और जब भी ये इंसिडेंट होता है, द सेम एक्यूज्ड इज फाउंड अराउंड दैट प्लेस. जहाँ पे भी ये इंसिडेंट हुए, सेम एक्यूज्ड वाज फाउंड अराउंड दैट प्लेस. देन इज दैट नॉट सजेस्टिंग दैट दिस एक्यूज्ड इज इन्वॉल्व्ड इन दिस? इफ देयर आर अदर सर्कमस्टेंशियल एविडेंसेस, then accused may have involved in the crime. अब सपोज आपके पास एक मकान है, मकान में आग लगा दिया, मकान में आग लग गई और यू क्लेम इंश्योरेंस. अब सपोज इंश्योरेंस कंपनी क्लेम्स दैट you deliberately puts fire to your house and we will not going to give you the insurance. So they are alleging a fraud upon you and therefore they are refusing to give you the insurance. Earlier also it was proved that in last 7-8 years you have purchased 5 houses and every house you get into fire, and every time there is new insurance company and from that you are claiming insurance. What is that? Is it not the transaction that is going on and you are the setter of the transaction, and therefore it suggests that this time it was not accidental fire, this time also it was intentional fire. अब ये illustration है, इसको हम देखेंगे. First of all read the section once more. When there is a question whether an act was accidental or intentional. Whether there is a question whether an act was accidental or intentional or done with a particular knowledge or intention. The fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. Now basically you see section 14 और 15 में main difference क्या दिख रहा है? Now you see 15 में they are saying about similar occurrences. They are talking only about similar occurrences. Or you can say that there was a series. Similar occurrences in a series. जबकि 14 में क्या है? 14 में similar occurrences भी relevant होंगे. Similar occurrences will also be relevant. Say any other incident, any other individual incident will also be relevant. Similar occurrence भी होंगे, any other individual incident भी होगा relevant, or any other statement or any conduct will also be relevant. So don't you find that section 14 is broader? In section 14 any fact will be relevant. It may be a statement, it may be incident, it may be similar occurrence, it may be conduct. Any fact will be relevant in section 14. But in 15 it will only the series, the transaction that will be relevant. And in every transaction, in every incident, it was same accused. Plus in 14 it is not only state of mind, it is a state of body also. It is a state of body feeling also. It is a state of bodily feeling also. बॉडीली फीलिंग के लिए आप इलस्ट्रेशन नंबर M पढ़ लीजिएगा 14 का, उसमें मिल जाएगा आपको बॉडीली फीलिंग. So it is a state of bodily feeling also, a state of mind also. It can be any state of mind. So again it is broader. Section 14 में any state of mind, intention, good faith, knowledge, whatever, and body and bodily feeling as well. जबकि 15 में क्या है? 15 में it may be any particular intention or knowledge, whether it was done with a particular intention or knowledge, or it was accidental. तो इधर इशू क्या है? Whether the act was accidental था या फिर act was with a particular intention or knowledge. That was the issue. तो इसमें और बाकी चीज नहीं आएंगी, जैसे गुड फेथ, फ्रॉडुलेंट एक्सेट्रा. फ्रॉडुलेंट इंटेंशन आ सकता है, लेकिन और चीज जैसे गुड फेथ, malice, etc., that will not fall in section 15. So you can say that section 15 is a species of section 14. 15 is narrower and 14 is broader. ये comparison आपसे एग्जाम में पूछ सकते हैं, therefore I am telling you. Section 14 is broader, not only from the perspective of the facts, it also broader from the perspective of the subject matter. इसको लिख लीजिए आप, write down. Section 14 is broader from the perspective of subject matter as well as the facts. Section 14 is broader from the perspective of subject matter as well as the facts, whereas Section 15 is limited. It relates only to a series of similar occurrences and to the fact whether the act was done intentionally or with particular intention or knowledge. Whether the act was done intentionally or with particular intention or knowledge or accidentally. Now let's see the illustrations. First one. A is accused of burning down his house in order to obtain money for which it is insured. A is accused of burning down his house in order to obtain money for which it is insured. The facts that A lived in several houses successively, each of which he insured, in each of which a fire occurred, and after each of which fires he received payment from a different insurance office, are relevant as tending to show that the fires were not accidental. मतलब आप जिस हाउस में रहोगे उसमें आग लग जाएगी, ये सब क्या है? जिस भी मकान में आप जाते हो उसमें आग लग गई. What does this mean? मतलब आप जानबूझ के कर रहे हो. अब इस वाले मकान में आप रह रहे हो, इसमें भी आग लग गई, and you are claiming insurance. So it is a part of series of occurrences, and that shows that it is not accidental, it is intentional. Next one. A is employed to receive money from the debtors of B. A is employed to receive money from the debtors of B. It is A's duty to make entries in a book showing the amounts received by him. He makes an entry showing that on a particular occasion he received less than he really did receive. The question is whether this false entry was accidental or intentional. Now he makes an entry showing that on a particular occasion he received less than he really did receive. मान लो कहीं 5 लाख रुपए उसने रिसीव किया और लिख दिया 5,000. रिसीव किया उसने 5 लाख पर लिखा है 5,000. मीन्स वॉट? मिस अप्रोप्रिएशन किया उसने. 4,95,000 रुपए का उसने मिस अप्रोप्रिएशन किया. अब सपोज ही सेज दैट नहीं नहीं ये एक्सीडेंटली हो गया. इट वॉज हेल्ड एक्सीडेंटली. Now when you examine that register you find at that several occasions he done same act. At several occasions he received more but writes less. Means what? It is a part of the series of occurrences and therefore it is not accidental. It was intentional. The question is whether this false entry was accidental or intentional. The facts that other entries made by A in the same book are false and that the false entry is in each case in favor of A are relevant. मतलब हर बार उसने एंट्री गलत किया है और कह रहा है कि एक्सीडेंटली हो गया और पहले भी एक्सीडेंटली हो गया था. और हर बार जो एंट्री हुई है गलत वो इन फेवर ऑफ ए हुआ है. मतलब कभी भी 5 लाख का 10 लाख नहीं हुआ. 5 लाख का 4 लाख या 5,000 कम ही किया है आपने. कभी भी ज्यादा नहीं लिखा 5 लाख का 7 लाख 6 लाख या 10 लाख. तो हर बार आपने एंट्री जो की है अपने फेवर में की है. सो दैट एंट्री वॉज डन डेलिब्रेट इंटेंशनल. नाउ नेक्स्ट इलस्ट्रेशन. A is accused of fraudulently delivering to B a counterfeit rupee. A is accused of fraudulently delivering to B a counterfeit rupee. The question is whether the delivery of the rupee was accidental. The facts that soon before or soon after the delivery of B, A delivered counterfeit rupees to C, D and E. Means what? Every time the counterfeit rupees was given and every time he was involved in the transaction. So this time also it was not accidental, it was intentional. So the facts that soon before or soon after the delivery of B, A delivered counterfeit rupees to C, D, E are relevant as showing that the delivery of B was not accidental. So that's it for this section. Read it again and differentiate with 15. 14 and 15 differentiate it. Now come to section 16. Read section 16. When there is a question whether a particular act was done, the existence of any course of business according to which it naturally would have been done is a relevant fact. It is a very simple thing. Now the question is whether क्या ये पर्टिकुलर एक्ट हुआ था. अब अगर आप प्रूव कर दो कि एक ट्रांजैक्शन है जो हमेशा होता है और ये एक्ट उसी ट्रांजैक्शन का पार्ट है और उस ट्रांजैक्शन का रिमेनिंग पार्ट हुआ था, देन ऑब्वियसली ये भी हुआ होगा. अब देखो कई बार एक नॉर्मल कोर्स ऑफ बिजनेस होता है. व्हेन देयर इज अ क्वेश्चन whether a particular act was done, the existence of any course of business according to which it naturally would have been done is a relevant fact. Now, the question is whether a particular letter was dispatched. Question is whether a particular letter was dispatched. Dispatched मतलब posted. The fact that it was ordinary course of business for all letters put in a certain place to be carried to the post and the particular letter was put in that place are relevant. अब मान लीजिए कोई ऑफिस है तो उसमें पर्टिकुलर डे के नोटिस रेडी किए जाते हैं एंड दे ऑल नोटिस आर केप्ट एट ए पर्टिकुलर प्लेस इन द on a table or somewhere, and from where on the next date the office boy collect all these letters and post them through the post office. One fine day question arose that I have not, the another party says that I have not received a letter, and the person is saying that I have posted the letter. अब ये जो question arose हुआ है, whether I have posted the letter or not, that has to be examined. अब if I prove that on that particular day I had come with the letter and I had kept those letters into on that place in that tray or table, then obviously in the ordinary transaction that letters have been take up by the office boy and will be posted. अब I am not saying that it is 100% sure that the letters were posted. हो सकता है स्टाफ ने उस दिन गलती की हो. That was a different thing. But when we are talking about the relevancy, the fact that I have put the letters in a particular place, that is a relevant fact to prove that the letter has been posted. Now, despite that letter was not posted, वो तो proof करना पड़ेगा, but otherwise the letter was posted. Now it is not a conclusive proof. वैसे otherwise letter वगैरह के cases में तो अब हमारी slip आ रही हैं and these slips are having the tracking report or delivery report. It is not a conclusive proof. हो सकता है उसके बावजूद letter post ना हुआ हो. अब मे बी टेक अदर एग्जाम्पल, जैसे लेटर पोस्ट किया. अब लेटर में के अंदर एनवलप के अंदर कुछ जो पर्टिकुलर फॉर्मेट था सबको सेम पोस्ट करना था. अब एक दो जो एनवलप है वो एम्प्टी छोड़ दिए, तो क्वेश्चन वो अराउज हो गया कि एम्प्टी एनवलप आया था. तो उसमें स्लिप भी एम पे ट्रैकिंग रिपोर्ट भी है, पहुंचा भी है एनवलप. अब उसी डे सेम डे अदर एनवलप भी गए, उनमें सब में गया है. दैट मिट बी ए रेलिवेंट फैक्ट कि अदर एनवलप में सेम मटेरियल मिला है बट इसमें क्यों नहीं मिला. हो सकता है उसमें भी स्टाफ की गलती हो, वो नहीं डाल पाई हूँ, भूल गए हूँ. बट दैट वुड बी रेलिवेंट दैट अदर पीपल ऑल्सो रिसीव्ड द सेम थिंग एंड पोस्टेड ऑन द सेम डे. Now next illustration. The question is whether a particular letter reached a. The question is whether a particular letter reached a. The facts that it was posted in due course and was not returned through the dead letter office are relevant. अब क्वेश्चन ये है कि क्या आपको एक लेटर मिला था, मैंने आपको पोस्ट किया, क्या लेटर आपको मिला. अब अगर मैं ये प्रूव कर दूं कि वो लेटर मैंने पोस्ट बॉक्स में डाला था, अब मैंने तो पोस्ट कर दिया इधर से, आई हैव पोस्टेड. अब कई बार क्या होता है, जो लेटर मिलता नहीं है सामने वाले को, उसको लेटर नहीं मिला बट आई हैव पोस्टेड. अब कई बार लेटर जब मिलता नहीं है सामने वाले को, then through the dead letter office that letter would come back to the address of person who posted it. और वो भी नहीं मिला है उस व्यक्ति को जिसने पोस्ट किया था, उसने अपना एड्रेस डाल रखा है. देन अब मान लो उसने नहीं भी डाला है तो डेड लेटर ऑफिस में होना चाहिए हुआ है लेटर, सो उधर भी नहीं मिला. सो दैट इज अ रेलिवेंट फैक्ट टू प्रूव दैट ही हैज रिसीव्ड द लेटर. Now here we are talking about the letter, normal letter. Here also we have talk about letters, not about the speed post registry. स्लिप मिलती है स्पीड पोस्ट रजिस्ट्री में, that would be proof. बट इसमें मैंने स्पीड पोस्ट और रजिस्ट्री के बारे में बताया था, एक एग्जांपल बताया था आपको of empty envelope. And then I am saying that it is not a conclusive proof. There may be facts which can be proved to prove the fact that the letter never reached, but at least it is a relevant fact that I have posted the letter, so you have received it. So you can take any example of any normal transaction that will be relevant under section 16. अब मान लीजिए कोई हॉस्टल में रहता है, वो कॉलेज जाता है डेली, या कॉलेज स्कूल या फिर कोचिंग, तो टिफ़िन आता है उसके यहाँ पर. अब डेली रूटीन का बिजनेस ट्रांजैक्शन है, वो कॉलेज गया, उस टाइम पर टिफ़िन वाला आया, टिफ़िन बाहर रख दिया उसने. व्हेन दिस पर्सन रिटर्न बैक टू द रूम, he take the tiffin and have it, and after having it he put the tiffin outside the room. And after that when the tiffin wala came and noon or sometime, he collect that tiffin and go back. अब एक दिन टिफिन वाला बोलता है कि I have not got the tiffin on particular day. हो सकता है कोई और ले गया और उधर टिफिन मिला नहीं। अब अगर इसमें वो स्टूडेंट ये प्रूव कर देता है कि इट इज द नॉर्मल कोर्स ऑफ ट्रांजैक्शन दैट ऑन सच एंड सो टाइम आई केम इनटू द रूम, आई टेक हैव द टिफिन, आई आफ्टर दैट आई kept it out, इतना प्रूव कर देता है, देन इज इट नॉट दैट इट इज यू हु टुक दैट टिफिन। तो ये जो ट्रांजैक्शन है उसका अगर एक पार्ट आप प्रूव कर दो, देन दैट पार्ट, जो एक पार्ट आप प्रूव कर रहे हो, दैट पार्ट वुड बी द relevant part, that part would be the relevant part for the remaining part to prove the remaining part. Now come to section 17, and by the section 17 onwards we would start the topic admissions. An admission is a statement. An admission is a statement, oral or documentary, or contained in an electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. अब देखिए, अगर आपसे कोई पूछे which section defines admission, then always say that it is section 17 till 20. अकेला एक सेक्शन डिफाइन नहीं कर रहा है, it is 17, 18, 19, 20. All of them together give the definition of admission. Because 17 give reference to other sections. 17 अपने आप में कंप्लीट नहीं है। अगर 17 आप ध्यान से पढ़ो, it is saying an admission is a statement. An admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. So this section itself talking about the subsequent sections, and therefore section 17 is a declaratory provision. It does not completely define admission. One dimension of admission it is defining, no doubts. It is saying an admission is a statement. अब देखिए, एडमिशन दो तरीके के होते हैं, एक तो होगा जुडिशियल एडमिशन और एक होगा एक्स्ट्रा जुडिशियल एडमिशन। अभी हम जो बात कर रहे हैं 17 एक्सेट्रा, दैट इज एक्स्ट्रा जुडिशियल एडमिशन। वी आर टॉकिंग अबाउट एक्स्ट्रा जुडिशियल एडमिशन। जुडिशियल एडमिशन वो होगा जो हम वी मेक प्लीडिंग्स इन द कोर्ट। फॉर एग्जाम्पल, यू राइट अ WS and in that you make a admission, or otherwise oral pleadings or written pleadings you make in the court proceedings. So that is judicial admission, and that is not our concern here. Our concern is outside the court, जो कि मैं कोर्ट से बाहर किसी वक्त पर करता हूँ, that is an admission. जैसे मैं बैठा हूँ चार लोगों के बीच में, ABCD, and I admit that on a particular day I have done that work, so that is admission. अब ये एडमिशन मैंने किसी जुडिशियल प्रोसीडिंग्स में नहीं किया। आई हैव मेड दिस एडमिशन बिटवीन 4 people, और आई हैव डन दैट एडमिशन इन ऑर्डिनरी कोर्स ऑफ बिजनेस। मैंने ऑर्डिनरी कोर्स ऑफ ट्रांजैक्शन में स्टेटमेंट दिया है, दैट इज अ एडमिशन ऑफ ए फैक्ट। अब एक पॉइंट है कि जो भी मैं बोल रहा हूँ या बात कर रहा हूँ किसी से, इज इट एन एडमिशन फॉर द पर्पज ऑफ दिस सेक्शन। अब इसमें एक पॉइंट ध्यान रखना, जो भी आप एडमिट करते हो वो इस सेक्शन के लिए एडमिशन नहीं माना जाएगा। कब तक? जब तक इट सजेस्ट एन इन्फ्रेंस रिगार्डिंग अ फैक्ट इन इशू और रेलिवेंट फैक्ट इन अ सूट और प्रोसीडिंग। अब मान लो मैं अभी आपसे कहता हूं कि ऑन टुडे आई विल गो एट सो एंड सो टाइम फॉर सो एंड सो पर्पज। अब मान लो किसी प्रोसीडिंग्स में ये सवाल उठता है कि उस दिन शाम को तुम कहाँ गए थे, तब मैं बोलता हूँ कि दैट आई वॉज हैविंग एन अपॉइंटमेंट विद द डॉक्टर सो एंड सो, या फिर आई हैड अटेंडेड ए मैरिज। और वही स्टेटमेंट मैं आपसे यहाँ पे बोल रहा हूँ दैट टुडे इन इवनिंग आई हैव टू गो फॉर ए मैरिज। तो अगर वो क्वेश्चन उठता है, देन वहां पर माई दिस स्टेटमेंट, मैं जो बोल रहा हूँ आपसे कि शाम को मुझे शादी में जाना है, दिस वुड बी रेलिवेंट। दिस एडमिशन जो क्योंकि बाद की प्रोसीडिंग से, तो ये जो पहले वाला एडमिशन है, by this admission would be relevant there. So that is what they are saying here. An admission is a statement, oral or documentary or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of persons. Now you see, which suggests an inference about what? About some fact in issue or relevant fact. And obviously that will be in any suit or proceeding. तो सिर्फ आप जो स्टेटमेंट्स करते हो वो अपने आप में रेलिवेंट नहीं हो जाएगा एडमिशन के फॉर्म में. रेलिवेंट तब होगा जब किसी सूट या प्रोसीडिंग में दैट फैक्ट इज ए फैक्ट इन इशू और रेलिवेंट फैक्ट. देन योर एडमिशन दैट यू मेड अर्लियर विल बी सेड टू बी रेलिवेंट. पहले तो हम रेलिवेंट की बात नहीं करते. यू कैन से देन योर एडमिशन statement will be considered to be an admission for the purpose of a relevant fact. Therefore, I always use the word. The concept of admission is a subjective concept. It is a subjective concept. Why? Because it cannot be seen in isolation. Admission cannot be seen in isolation. अब आज मैं कोई भी सेंटेंस बोलता हूँ. फॉर एग्जाम्पल मैं टुडे स्टेटमेंट देता हूँ दैट टुडे आई एम स्टेइंग इन सो एंड सो होटल. सो आई मेक a statement I make a admission that I am staying in so and so hotel. But the point is whether my statement admission माना जाएगा section 17 के लिए. Answer is no. But if tomorrow there is a suit or proceeding, and in that if a question arises as to where do you stayed on so and so date, so in that case whatever I said today will be considered to be an admission. So admission for the purpose of Evidence Act, extrajudicial admission, always to be seen in the context of a fact in issue or relevant fact in a suit or proceeding. Read it once again. An admission is a statement, oral or documentary or contained in an electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. So they are saying that admission is a statement, and the statement can be an oral statement, documentary statement, or it can be in electronic form, and such a statement has to be seen in reference to a suit or proceeding. Means if you see the statement in isolation, that cannot be an admission. A statement, in order to be an admission, we always has to be in reference to a suit or proceeding. And it is not necessary that suit or proceeding is pending at that time when you gave the statement. It may be the suit or proceeding may be filed later on. Now, in reference to that suit or proceedings, if that statement is suggesting an inference about what? About a fact in issue or relevant fact in that particular suit or proceeding, then it will be an admission, provided that it was made by. Then it will be an admission provided it is made by a person as specified in 1819 etc. and also in the circumstances as specified in 1819 etc. Means only section 17 is not the complete definition of the admission, but the person and the circumstances has to be examined. The person and the circumstances has to be examined in section 18, 19, etc. Means the statement has to be made by a person plus in circumstances, person plus in the circumstances specified where? 18 till 20, then it will be considered to be an admission. So a statement of its own will never be an admission. A statement, in order to be an admission, has to be always to be seen in reference to a suit or proceeding, has always to be seen in reference to suit or proceeding, and in that suit or proceeding we find out the fact in issue or relevant fact, and you see whether that statement is suggesting any inference about the fact in issue or relevant fact, and if yes, then if it was made by a person who has been described in section 18 till 20, and in those circumstances, then only it will be an admission. You see, there are three things. One is the statement, the other is the admission, and third one is the confession. Statement, admission, and confession. The statement is the broadest. In order to be an admission, the conditions of 17 till 20 to be fulfilled. So, a statement is just a statement. A statement is just a statement, and in order to amount an admission, it has to be fulfilled the requirements of section 17 till 20. And there, if there is an admission of guilt, then it will amount to confession. If there is an admission of the guilt in a criminal matter, then it will amount to confession. इसमें एक स्टेटमेंट लिख लो, एक पॉइंट लिख लो. Statement is the genus. Statement is the genus, whereas admissions is the species and confessions is the subspecies. मतलब स्टेटमेंट को अगर आप जीनस मानते हो तो एडमिशन जीनस होगा और कन्फेशन सब स्पीसी होगा, और अगर आप एडमिशन को जीनस कहते हो देन कन्फेशन विल बी द स्पीसी. इसको भी लिख लो आप, राइट डाउन. इफ एडमिशन इज कंसिडर्ड टू बी द जीनस देन कन्फेशन विल बी द स्पीसीज. If admission is considered to be the genus, then confession will be the species. Now next paragraph. Statements per se will not be an admission. Statements per se will not be an admission even if it admits a particular fact. Admissions is a subjective concept, and in order to be an extrajudicial admission, the statement will have to subscribe to the following conditions. Number 1, it should be seen in reference to some suit or proceeding. It should be seen in reference to some suit or proceeding. Thus, such suit or proceeding may have been pending at the time when the statement was made, or it may have been instituted after the statement was made. अगर कोर्ट में सूट चल रहा है और आपने कोर्ट के बाहर कहीं भी उस सूट से रिलेटेड कोई फैक्ट इन इशू या रेलिवेंट फैक्ट के बारे में, कोर्ट प्रोसीडिंग्स में नहीं, कोर्ट प्रोसीडिंग्स के बाहर कहीं भी आपने कुछ एडमिशन कर लिया, कुछ स्टेटमेंट कर लिया, एंड दैट ऑल्सो बी सीन दैट द कंडीशंस आर फुलफिल्ड, और you made a statement today and the suit is filed 2 years after or 6 months after, then also it will be an admission if the conditions are fulfilled. Now next point, it is necessary that such a statement was made not in any judicial proceedings. Thus, in that case, it will be called a judicial admission. Full stop. In order to be an extrajudicial admission for the purpose of section 17, it is essential that the statement should have been made out of any court proceedings. Now next point. The statement should be such as suggest an inference about the fact in issue or relevant fact of the said suit or proceedings. Next point. It should be made by such person and in such circumstances as it declare under section 18 till 20. So I hope you understand section 17. 17 says that it is an admission is a statement, oral or documentary or contained in electronic form. So first of all it says that it is an admission, and we know that the statement can be oral, etc. And a gesture also amounts an statement. Calling of a person by hand and not saying anything, so that kind of gesture will always amount to an statement. So इसको भी लिख लो आप. Gestures also in proper cases may act as statement. किसी ने आपसे कुछ पूछा और आपने सिर हिलाकर मना कर दिया. So that gesture of rotating head is a statement. जैसे किसी ने आपसे पूछा क्या कल तुम वहां पर गए थे, तो आपने सिर हिलाकर मना कर दिया. So that is a gesture that I did not go. या फिर आपने हाँ की फॉर्म में सिर हिला दिया ऊपर नीचे, that it means that I go. So even gestures also in proper case may act as a statement. So first they are saying there is a statement, then saying which suggests an inference as to any fact or in issue or relevant fact. Then they are saying which suggests an inference regarding a fact in issue or relevant fact. इसीलिए मैंने बोला इट इज अ सब्जेक्टिव कॉन्सेप्ट, क्योंकि जब तक कोई फैक्ट इन इशू या रेलिवेंट फैक्ट नहीं होगा तब तक आप स्टेटमेंट को एडमिशन नहीं बुला सकते, क्योंकि द वेरी एसेंस ऑफ द एडमिशन इज लाइज फैक्ट दैट इट इज सजेस्टिंग एन इन्फ्रेंस रिगार्डिंग fact in issue or relevant fact in a particular suit or proceeding. And therefore you see fact in issue or relevant fact when they are saying, then there is some suit or proceeding either pending at the time of the statement or may be filed later on. Suit or criminal proceeding. It can be quasi civil proceeding also. For example 125 CRPC. So it can be civil, criminal or quasi civil proceeding. So suit or proceeding means criminal, civil और quasi civil proceeding. अब सूट लिखा है तो सिविल लिखने की जरूरत नहीं है, बट सिविल में भी प्रोसीडिंग्स होती हैं जैसे एग्जीक्यूशन प्रोसीडिंग्स. सो एग्जीक्यूशन वी विल नॉट कॉल ए सूट, इट इज अ सिविल प्रोसीडिंग. सो दैट्स व्हाई आई कॉल्ड क्रिमिनल प्रोसीडिंग्स, सिविल प्रोसीडिंग्स और क्वासी सिविल प्रोसीडिंग्स. फॉर एग्जांपल क्वासी सिविल का एग्जांपल जैसे 125 CRPC. So there has to be a criminal, civil or quasi civil proceedings, civil, criminal or quasi civil proceedings, or a suit in which there is some fact in issue or relevant fact, and the statement of the person concerned is suggesting an inference about such fact in issue or relevant fact. And the last point they are saying is what? That it should be made by some such person plus in some such circumstances as is specified hereinafter, that is section 18 till 20. तो देखो जो नेचर ऑफ स्टेटमेंट क्या होगा वो तो बता दिया 17 में, कब किया जाना चाहिए वो भी इम्प्लाइडली बता दिया सेक्शन 17 में. Not impliedly, it should not be, they said that it should not be judicial statement. So what should be the nature of the statement? That is clearly stated that it should suggest an inference. In reference to what? In reference to fact in issue or relevant fact in a suit or proceeding. And who will make the statement and in what circumstances he will make the statement, that you will find in 18, 19 and 20. So admission होना चाहिए, ये जुडिशियल स्टेटमेंट नहीं होगा, इट इज़ एन एक्स्ट्रा जुडिशियल स्टेटमेंट. और ध्यान रखिएगा कि नेचर आपको ऑलरेडी समझ में आ गया सेक्शन 17 में. अब 18, 19 एंड 20 टॉक्स अबाउट हुज स्टेटमेंट इज रेलिवेंट, whose admission is relevant. अब देखो एडमिशन, अब मान लो ए और बी के बीच में कोई सूट चल रहा है। अब बी ने या ए ने कभी कोई स्टेटमेंट किया था। अब ए और बी तो पार्टीज हैं, तो पार्टीज का स्टेटमेंट तो एडमिशन होगा ही होगा। इफ इट वाज द पार्टी हु हैड मेड द स्टेटमेंट, और मे बी एन एजेंट ऑफ द पार्टी। If it was the party or an agent of the party, in that case, obviously it was admission for the purpose of section 17, if the conditions of 17 are fulfilled. अब मान लो, if A makes a statement today, suppose I entered into a contract today with someone, and I tell you that I entered into a contract with D. I have entered into a contract with some person B. So A tells that I have entered into a contract with some person B today. Maybe 6 months after, the contract has to be performed, and A did not perform the contract. Suppose it was an oral contract. B files a suit against A, claiming damages for the breach of contract. A says that I never entered into a contract. A कहता है कि I never entered into a contract. So can B get any of you before whom the statement was made, any of you as a witness of admission and prove that A had admitted earlier that I have entered into a contract. अब इस केस में फैक्ट इन इशू क्या है? As to whether A had entered into a contract or not. As to whether A had entered contract with B or not. यही तो है फैक्ट इन इशू. And the other one is whether A had committed a breach of contract or not. So the main fact in issue, because A is saying that I had never entered into a contract with B, so the fact in issue is whether A entered into a contract with B. So that fact in issue, the statement that he had made earlier, will not suggesting an inference that yes, he has entered into an contract, and therefore that statement of A will be considered to be an admission. Whether it would be allowed to be proved or not, that will be depend upon relevancy, and that we will talk in section 21. But at least it would be considered to be an admission, क्योंकि ये एक ऐसे व्यक्ति ने कहा था जो उस सूट का पार्टी है. He himself is a party. अब either party to the suit makes a statement earlier or his agent makes an statement, that will be considered to be an admission if section 17 is fulfilled. अब उसी तरीके से if you say A and B are representative to a group of person. अब मान लो कोई क्लास है, your class of students, जिस क्लास है उसमें कोई मॉनिटर बना देते हैं, एक गर्ल मॉनिटर एक बॉय मॉनिटर. अब जो मॉनिटर हैं क्लास के वो दे आर द रिप्रेजेंटेटिव नाउ. अब देयर इज इफ वन मॉनिटर. अब if today if that monitor makes a statement as a capacity of representative, if he makes a statement today in his capacity of representative, in his capacity as a representative of that class, later on there is suit between this class and someone in which obviously he was a representative, so obviously he was representing them, all persons in the suit. That person who is the representative will representing all people of class in the suit. So in that suit between him, the representative, and the third person, in that suit, whatever statement made by the representative earlier will be considered to be an admission. It will suggest an inference regarding the fact in issue or relevant fact, provided that you have made that statement earlier that was made in a representative capacity. जब उसने पहले स्टेटमेंट दिया था, that statement was in his representative capacity. अगर उसने अपनी इंडिविजुअल कैपेसिटी में स्टेटमेंट दिया था, then that statement will not be an admission. Then that statement is not an admission in the representative suit. Simply speaking, a representative suit. Suppose the plaintiff is a representative and the statement made by the representative earlier, that statement will be an admission only when it is proved that he had made the statement in his representative capacity. If he had made a statement in his individual capacity, then in representative suit it is not admissible. रिप्रेजेंटेटिव सूट मतलब क्या, वो रिप्रेजेंटेटिव की तरह कंटेस्ट कर रहा है, तो वहां पर जो उसका स्टेटमेंट आप एडमिशन बना रहे हो, so the statement should also made by him in a representative's capacity. So these two rules, parties to the proceedings, their statement is an admission, agent to the parties, their statements are a admission. Parties to the proceedings, their statement will be an admission. Agent to the parties, their statement will be admission. And representative suit का जो representative है, that representative if made her statement or his statement earlier in a representative capacity, that will also be considered to be an admission. That statement will also considered to be an admission. These are called the rules of privity. Rules of privity. Privity means what? Privity means the parties who are private to that transaction. So A and B are the parties to the contract, no? So A का statement, B का statement admission माना जाएगा. That is the rule of privity. A के agent का statement, B के agent का statement admission माना जाएगा. Then also rule of privity. अगर representative suit है, so A is contesting as representative with B, so A's statement in the representative capacity will also be an admission, and that is also called rule of privity, क्योंकि इसमें they are parties to the suit or proceeding. लेकिन कुछ ऐसे लोग भी हैं, those who are not parties to the suit, but their statement will also be considered to be an admission for the purpose of Evidence Act. So such cases where a third person's statement will be considered to be an admission, and such cases are called exceptions to the rule of privity. They are called exceptions to the rule of privity. So party या उसका कोई एजेंट या एक रिप्रेजेंटेटिव सूट में रिप्रेजेंटेटिव, अगर इनका कोई स्टेटमेंट है, then that is a rule of privity. Statement made by party, agent or representative in a representative suit, then it is rule of privity. लेकिन अगर कोई थर्ड पर्सन, जो इनमें से कोई नहीं है, सम थर्ड पर्सन, अगर उसका कोई स्टेटमेंट है और एडमिशन के फॉर्म में अलाउड है, then that is exception to the rule of privity. So this is what you find in section 18. This is all you find in section 18. So get ready with section 18 in the next lecture. पढ़कर आना इसको एक बार. That's it for this lecture. Thank you for watching lecture.